Welcome to The Explainer. Listen, if you're a founder in India, you know your brand is everything. So today, we're going to break down the essential guide to protecting that brand with a trademark. So think about it. You've poured your heart and soul into creating a name, a logo, a whole identity for your business. But here's the scary part. Without the right legal safeguards, that identity is just, well, it's vulnerable. So in this explainer, we're going to walk through the absolute essential steps to make sure your most valuable asset is locked down and secure. Okay, before we get into the nitty-gritty how-to, let's just pause and talk about the why. Because really, understanding the power of a registered trademark, that's the crucial first step. And boom, this is where it all clicks into place. Look at the difference. Without registration, you're kind of stuck with common law. Think of it like the unwritten rules of the playground. You have to prove something called passing off, and trust me, it is a total uphill battle. But with a registered trademark, now your protection is literally baked into the law. You can sue directly for infringement. It's just so much cleaner, stronger, and way more decisive. So here's the bottom line, the most crucial takeaway. Registration transforms your brand from just a cool idea into a legit, legally recognized asset. That certificate, it's not just a piece of paper to frame. In a courtroom, that thing is powerful, definitive proof that you own it. End of story. Okay, so you're on board, right? You get it. But hold on. Before you just dive headfirst into the application, there are 4 really big questions we need to answer together. And seriously, getting these right from the get-go is going to make the whole process so much smoother. First up, the who. Who can actually file for one of these? You might be surprised at just how broad the answer is here in India. So, the key legal word here is proprietor, but don't let that throw you. It basically covers a huge range of people. We're talking an individual with a brand new idea, a company that's been around for years, even a family member who inherits a business. And the law is super clear on this. It doesn't matter if you're already using the mark or you're just proposing to use it. Either way, you have the right to file. All right, question 2, the when. You know they say timing is everything, right? So when exactly is the perfect moment to file that application? And do you even have to? First off, no. The law doesn't force you to do this. It's totally optional. But the ideal time to file, it's when you're really confident that your brand name, your logo, whatever it is truly distinctive. You know, it has to be able to stand out from the crowd and actually distinguish your stuff from everyone else's. And it has to be something you can draw or show graphically. When you hit that point, that's the sweet spot. Okay, so we've got the who and the when down. Now let's get into the how. How do you actually file the application? Let's get practical. Yeah, this isn't a one-size-fits-all kind of deal. The form you use really depends on what you're trying to do. So let's say you're just in a single category, like clothing. You'll file what's called an ordinary application. But what if you want that same brand to cover both clothing and, say, software? Well, then you're going to need a multi-class application. And for all the international brands out there, there's a whole other path called the convention route. And our last big question, the where. This one's important. You can't just send your application off to any old address. It has to go to the right office. So how do you figure out which one is yours? It all comes down to your principal place of business in India. See, the country is divided up into different territories, and each one of these 5 offices you see here covers a specific set of states. So, for example, if your business is headquartered in Maharashtra, your application is going to the Mumbai registry. Simple as that. So, you've answered the 4 big questions, you've filed your application, and you might be thinking, phew, I'm done. Well, not quite. In fact, the real journey is just getting started. Your application now enters this formal process. And it's got a pretty intense name, Trademark Prosecution. And this is basically the roadmap for that journey. First, you file. Then it goes to an official examiner who scrutinizes everything. If they give it the green light, it gets advertised in the Trademark Journal for the whole world to see. And that's when a window opens up for anyone to oppose it. Only after you clear that hurdle can your mark finally be registered. So let's zoom in on that examination phase for a sec. So when the registrar is looking at your application, they've got a few choices. They can accept it as is, they can refuse it, or they can accept it but with some conditions attached. But here's the thing, this isn't just some random decision. And this is really important. They are legally required to give you, in writing, the reasons for any refusal. That's what keeps the whole process fair and transparent. All right, so your mark made it through the internal exam, it gets published in the Trademark Journal, and now it faces its first public test. This is what's known as the opposition stage, and believe me, it is a critical hurdle you have to clear. 4 months. That's it. That is the strict, totally non-negotiable window for anyone to file an objection once your trademark is published. If they miss that deadline, the chance is just gone. Forever. And you have to pay attention to the exact wording from the law here. It says, any person. That doesn't just mean your competitors. We mean literally anyone, your neighbor, a customer, anyone who thinks your trademark shouldn't be registered has the legal right to file an opposition. So what happens if someone actually does file an opposition? Well, the whole thing doesn't just grind to a halt. It basically turns into a mini trial. The registrar has to hear arguments from both sides, from you, the applicant, and from the person who's opposing. And it's only after they've heard both sides of the story that they can make a final call. Okay, so you've done it. You navigated the application, you passed the exam, you cleared any opposition that came your way. So, congratulations, your trademark is officially registered. But what does that really mean? What do you actually get for all that hard work? This right here, this is the payoff. This is the reward for that whole journey. First, you get exclusive, nationwide rights to use your mark for whatever you registered it for. Your certificate becomes ironclad proof that you're the owner. And get this, as long as you keep renewing it, that right can last forever. Your brand isn't just a brand anymore. It is officially, legally a protected asset. And that really is the most important point to leave you with. Getting a trademark isn't just about playing defense. It's about building a solid foundation. Once your brand's identity is legally locked down, you're free to focus on the big stuff, building its value, expanding its reach, and growing your business with some real, genuine confidence. So the question is no longer if you're protected, it's what are you going to do with that newfound security?